Before I begin, I need to note that some of the specifics that support my testimony cannot be discussed in open session. I understand and am sensitive to the fact that FISA and the Protect America Act and the types of activities that these laws govern are of significant interest to the Congress and to the public. And for this reason, I will be as open as I can, but such discussions do come with a degree of risk. It is my belief that the first responsibility of the intelligence community is to achieve understanding, and secondly, to provide warning from that understanding. As the head of the nation's intelligence community, it is not only my desire but my duty to encourage changes in policies and procedures, and where needed, legislation, to improve our ability to provide warning of terrorists or other threats to our country. On taking this post, it became clear to me that our intelligence capability was being degraded. I learned that collection, using authorities provided by FISA, continued to be instrumental in protecting the nation, but due to changes in technology, the law was actually preventing us from collecting needed intelligence. I asked what we could do to correct the problem. FISA is the nation's statute for conducting electronic surveillance and physical search for foreign intelligence purposes. I emphasize foreign intelligence purposes. When passed in 1978, FISA was carefully crafted to balance the nation's need to collect foreign intelligence information with the need for protection of civil liberties and privacy rights of our citizens. The 1978 law created a special court, the Foreign Intelligence Surveillance Court. The court's members devote a considerable amount of their time and effort while at the same time fulfilling their district court responsibilities. We are indeed grateful for their service. FISA is a very, very complex statute. It has a number of substantial requirements. Detailed applications contain extensive factual information and require approval by several high-ranking members of the executive branch before they can even go to the court. The applications are carefully prepared, subject to multiple layers of review for legal as well as factual sufficiency. It is my steadfast belief that the balance that the Congress struck in 1978 was not only elegant, it was the right balance. Why did we need the changes that the Congress passed just last August? FISA's definition of electronic surveillance simply did not keep pace with technology. Let me explain what I mean by that. FISA was enacted before cell phones, before email, and before the Internet was a tool used by hundreds of millions of people around the world every day, to include terrorists. When the law was passed in 1978, almost all local calls were on a wire, and almost all international communications were in the air, or how we would refer to it as wireless communications. Therefore, FISA was written in 1978 to distinguish between collection on a wire and collection out of the air. Today, the situation from 1978 is completely reversed. Most international communications are on a wire, fiber optic cable, and local calls most often are in the air. FISA also originally placed a premium on the location of the collection. Because of these changes in technology, communications intended to be excluded from FISA in 1978 were frequently included in the current interpretation. This had real consequences. It meant that the intelligence community, in a significant number of cases, was required to demonstrate probable cause to a court in order to target for surveillance the communication of a foreign person located overseas. Because of this, the old FISA requirements prevented the intelligence community from collecting important foreign intelligence information on current terrorist threats. In the debate over the summer and since, I have heard individuals from both inside and outside the government assert that threats to our nation do not justify this authority. Indeed, I have been accused of exaggerating the threats that face our nation. Allow me to attempt to dispel this notion. The threats that we face are real, and they are indeed serious. In July of this year, we released the National Intelligence Estimate, commonly referred to as an NIE, on the terrorist threat to the homeland. An NIE is coordinated among all 16 agencies of the community, and it is the intelligence community's most authoritative written judgment on a particular subject. The key judgments from this NIE are posted on our website, dni.gov. I would encourage members and our citizens to read the posted NIE judgments. In short, These assessments conclude the following. The United States will face a persistent and evolving terrorist threat over the next 3 years. That's the period of the NIE. The main threat comes from Islamic terrorist groups and cells, and especially Al-Qaeda. Al-Qaeda continues to coordinate with regional terrorist groups, such as Al-Qaeda in Iraq, across North Africa, and in other regions. Al-Qaeda is likely to continue to focus on prominent political, economic, and infrastructure targets with the goal of producing mass casualties, visually dramatic destruction, significant economic aftershock, and fear among the United States population. These terrorists are weapons proficient, they're innovative, and they're persistent. Al-Qaeda will continue to acquire chemical, biological, radiological, and nuclear material for attack, and they will use them given the opportunity. Globalization trends and technology continue to enable even small groups of alienated people to find and connect with one another, justify and intensify their anger, and mobilize resources for attack, all without requiring centralized terrorist organization, training camp, or a leader. This is the threat we face today, and one that our intelligence community is challenged to counter.
Moreover, the gentleman's time is nearly up.
Moreover, the threats we face as a nation are not limited to terrorism. It also includes weapons of mass destruction. The Protect America Act updated FISA and passed by the Congress, signed by the President on the 5th, has already made the nation safer. After the law was enacted, we took immediate action to close critical foreign intelligence gaps related to terrorist threats. I want to close with noting 5 pillars in the law that enabled us to do our mission. It clarified that the definition of electronic surveillance under FISA should not be construed to encompass surveillance directed at a person reasonably believed to be located outside the United States. That's a very, very important feature. Under the Act, we're now required to permit the FISA court, submit to the FISA court for approval the procedures that we use to determine that the target of acquisition is located outside the United States. This portion is new and was added to give the Congress and the public more confidence in the process. In addition to oversight by the Congress, the new FISA process allows a review of the procedures by the FISA court. The third thing was the Act allows the Attorney General and the DNI to direct third parties to cooperate with us to acquire foreign intelligence information. Fourth, the Act provides limited protection, liability protection for private parties who assist us when complying with lawful directives issued under the FISA Act. And most importantly, with one in which I personally identify, FISA as amended continues to require that we obtain a court order to conduct electronic surveillance or physical search against all persons located inside the United States. I want to assure the Congress that we will cooperate in executing this law and subject to the appropriate oversight not only by the Congress but by the court. So that concludes my opening statement.